Hi, my name is Paul Horn. I am a California attorney. I'm also a CPA. Of course, I'm from the law office of Paul Horn. I do probate, bankruptcy, and living trust. The question of the day is this: if you have a probate listing, the question is, can you double end your probate transaction? Okay? So, in any real estate transaction or probate, the source, the first piece of paper that I want you to look at is called letters. Take a look at letters. Letter is a court form DE 150 issued by the court. It's gonna have the court certified seal here. See this seal by the court? This form is gonna have the attorney's name on it. It's gonna have the case number on it. It's gonna identify your personal representative, and it's gonna say full authority or limited authority. Full or limited authority. All right. With full authority, here is the with full authority, the court will never see your transaction. Okay, so as long as you've done your very best, as long as you try and get the best price for the estate, meaning you put on the MLS, you do multiple open houses, and that's the best offer, and it's your buyer, no problem. You can double end it. That's fine. Now the question, if it's limited authority, it's gonna go in front of the judge. That's gonna be a court confirmation process. Can you double end that transaction as well if it's limited authority? So in limited authority, how it works is this. In limited authority, the first thing that's going to happen is once the publication period, the newspaper is done, you've done your best, you have an offer. That offer, you give it to the attorney. The attorney's going to file a form. It's going to file a form called Report of Sale and Petition for Order Confirming Sale of Real Property. What he's going to do with that is he's going to file with the court. The court's going to give him a court date. For example, this was done yesterday, November 18th. Okay, 8:30 at 5 p.m. at Department 5, excuse me. So that's gonna happen, and then this form basically is gonna tell the judge, hey judge, we're selling it for, in this example, we're selling it for 310, and by the way, the commission is basically 5%, and the commission is 5%, and this particular agent actually is double ending it. So the question is that okay in a limited authority? So my advice to you now, by the way, this particular case, see it says 100% going to a particular agent, 100%. Double ending a deal in a probate transaction, it's okay as long as you've done your very best. So what I advise realtor to do is in a limited authority transaction or probate, put on the MLS. Put on MS, when is the court date? When is the court date? When is the court confirmation? Because you want to tell the whole world, hey, the whole world at 8:30 and such a date, this case going in front of the judge, and if you want to come and outbid us, no problem. It happens that I've got my own buyer, but hey, I want to let the whole world know because I want to do my very best to get the best price for the state. So if you've done your very best, you have fulfilled your fiduciary duty, it's okay to double end even though it's a limited authority case. So look, I hope this helped in your probate transaction. This is Paul Horn, and I will see you at my probate seminar. Thank you.